Look, divorce is one of the most stressful things anyone can go through. And let's be honest, money is a huge part of that stress. So today, we're going to talk about building your financial fortress. We're going to explore exactly what kind of money is typically considered off limits in a divorce, giving you the clarity you really need. Let's jump right in. It's the big question, right? When a marriage ends, what assets do you actually get to keep, no questions asked? Well, the answer is a little more complicated than you think, but, understanding the core principles here can make all the difference in protecting what is rightfully yours. All right, so here's our roadmap for the next few minutes. First, we'll define that financial fortress, what's protected. Then we'll look at how those defenses can get, breached. After that, we'll cover the tools you can use for protection, the super important role of state law, and finally, we'll get into some practical next steps you can take. Okay, section 1. Let's start by building the walls of your fortress. The whole legal idea behind this defense is something called separate property. And trust me, it's the foundation for everything else we're going to talk about. Think of it as the clear line in the sand between what's yours and what's ours. So what is it exactly? Well, to put it simply, separate property is anything that belongs only to you, not to the marriage. But did you notice that key phrase on the slide? As long as they are handled correctly. That, my friends, is the fine print. And it's where things can get really tricky, and where those fortresses can start to crumble. So what are the actual building blocks of this fortress? Well, it's things that have a clear origin story tied only to you. For example, maybe it's a 401k you started before the marriage, or an inheritance left specifically to you by your grandmother, not to you as a couple. A significant gift from your parents, just for you. Even some personal injury settlements are often considered separate. And of course, there's anything you both explicitly defined as separate in a legally solid prenuptial agreement. Now for the really crucial part. Even the strongest fortress can have its walls breached. Let's get into how your protected, separate property can suddenly become totally vulnerable to being divided, often through simple mistakes you didn't even realize you were making. Here it is, the number one rule. The moment you mix that untouchable money with marital funds, or you use it for the benefit of the marriage, like paying the mortgage on the family home, you risk changing its legal status forever. That clean line between yours and ours starts to get really blurry. And believe me, once it's blurred, it's incredibly difficult to unblur it. So this slide shows the two main ways this happens. Over on the left, you see commingling. Picture this. You inherit $50,000. Awesome. Then you deposit it into the joint checking account you share with your spouse. You pay a few bills, buy groceries. You've just commingled your funds. And now it's a total nightmare to trace what part is still your inheritance. Then on the right, you have transmutation. This is more direct. It's like taking that house you owned before you ever got married and adding your spouse's name to the deed. Both of these actions can permanently change separate property into marital property. And, there's a third silent threat that makes the other two possible. Just plain bad bookkeeping. If you can't prove where the money came from, if you can't show a clean paper trail proving it started as a separate asset, a court might just have to assume it's marital property. The burden of proof? It's on you. And this lack of a clear paper trail, it leads to a really serious risk. If the funds are too mixed up or the records are a mess, a court might just throw up its hands and declare the whole thing, your entire inheritance, for example, as marital property, totally up for division. The fortress wall doesn't just get a crack, it completely crumbles. Okay, so that's the risk. It sounds a little scary, I know, but how do you proactively reinforce those walls? Let's talk about the legal tools you can use to protect your separate assets, ideally long before a problem ever comes up. You actually have some powerful shields at your disposal. The one everyone knows is a prenuptial or postnuptial agreement. It's basically a custom-made rulebook for your finances. Certain types of trusts can also create a really strong barrier, putting assets under the control of a neutral third party. And for all you business owners out there, having meticulous corporate records that clearly separate your business from your personal finances is absolutely essential. All right, now for a huge disclaimer. Everything we've just talked about depends entirely on where you live. The rules for dividing property are set state by state, not at the federal level. This is a factor you absolutely cannot ignore because the default rules can be drastically different from one state to the next. Broadly speaking, states fall into two big buckets. In community property states, think California or Texas, the starting point is that pretty much any asset or income earned during the marriage is owned 50-50. It's a very clear-cut rule. But in the majority of states which use equitable distribution, courts have more wiggle room to decide what's a fair split. They might look at things like how long you were married or each person's future earning potential. So a fair split might not be 50-50 at all. In both systems, separate property is usually excluded, but how strictly that rule is applied can vary a lot.
So, with all that in mind, what can you actually do if you're worried about protecting your assets? Well, that brings us to our final section, your action plan.
It really boils down to 3 simple, powerful steps. First, gather your documents. Find every single statement, gift letter, or inheritance record that proves where an asset came from. Second, if you're even thinking about a separation, just hit pause. Stop moving funds around or changing titles on things. Don't transfer that inheritance into a joint account. And third, and this is by far the most important, talk to a local family law attorney. They are the only people who can give you advice based on your specific situation and your state's unique laws. So we'll leave you with this one last thought. At the end of the day, protecting your separate property all comes down to traceability. Can you tell a clear, simple, and provable story about where your money came from and where it has been? Because in a legal fight, a clear story that's backed up by documents is your strongest defense. Sometimes it's your only defense.